Hi, everyone. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And over the last few weeks, months, and even years, we've been talking about personal injury cases. And specifically, we've been commenting on trials and jury verdicts and how an injury victim can obtain full justice, not by taking the lowball offer that the insurance company gives you, but by going to trial, by being fearless, by preparing, and by going to trial. So today, I wanted to look at an actual trial. This case actually was completely videotaped, the entire trial, and it was on CVN, the Courtroom View Network. It was a long trial, I think 4 or 5 weeks, and it was an interesting case. It was a rear end hit by a truck to a lady in a car, and she suffered a fusion as well as a traumatic brain injury. And there were a lot of witnesses called for the plaintiff, a lot of different doctors, circle of friends, witnesses. The plaintiff, of course, testified. So let's take a quick look. I mean, there's a lot of footage because, like I said, this is a 5 or 6 week trial. But what we could do is we could look at a few highlights and I can comment on it and we could do it together. So let's take a look. This right now is going to be the opening statement that happened for the plaintiff. And there were 2 different lawyers that gave the opening for the plaintiff. One lawyer started with the opening as to liability, or who was at fault, and then another lawyer took over and talked about damages or all of the harms and losses that the lady suffered. So let's go look into a little bit about the liability opening.
All right, Mr. Bruno, you're going to go first.
Yes, thank you.
You may proceed.
Good morning, everybody. Sorry, I almost left the podium lectern. In the beginning, in the opening statement, the mini opening statement that the defense gave, they said that this case had taken on a life of its own over these 9 years. And we agree. And I'm going to talk to you about the liability, who's responsible. And I think that answers that very question of why this case has taken on a life of its own. So liability is simply who is at fault, all right? And as a juror, one of your jobs is, the first job, as Mr. Rowley discussed, the 3 columns of information that you have to decide is who's responsible. What does it mean to be responsible for this wreck? What does it mean to be accountable for that? And then how do you go about making a decision in terms of what tools do you use? When we spoke with some jurors prefer analytical tools or objective tools. Other jurors are going to listen intently to what the people say about what happened and make a decision that way. And collectively, you're going to use all of these things, photographs, witness statements, expert witnesses, and the police officer who was out at the scene in order to determine what happened and who's responsible. And I would ask you, as we continue this trial, to keep in mind what we discussed yesterday, which is that a jury evaluates the credibility of both sides. Who is giving you the straight scoop?
So this is interesting, right? Right from the beginning, he talks about responsibility, and that's a theme that you're going to see in this trial, but it's also a theme you see in a lot of trials. And what is responsibility, right? What does it mean to be responsible? Because a lot of the time, and I've had it happen in my cases as well, the defendants, they'll admit liability right before a trial starts. And then they'll get up there and say, we are responsible. Look, we took responsibility. But is that real responsibility? And a lot of lawyers, they'll give an example of a boy, let's say your son, right? He's playing baseball and he breaks a neighbor's window. And is it enough to just go over to the neighbor and say, you know, I was playing ball and I broke your window, I'm sorry, and then leave? That's not real responsibility. Real responsibility would be 3 things. It would be to go over there and say, look, I was playing baseball, I broke your window, I'm sorry. Number 2, it's my fault. And number 3, let me make it right. Let me pay for it. How much did the window cost? Let me put in a new window. Let my father write you a check, right? That's real responsibility because you're essentially admitting it, you're saying sorry, and the third thing is you're making it right, you're paying for it. And the defendants don't agree to do that. So that's one part of the theme. The second part was credibility, and that is believability, right? Are the witnesses credible? Now, just because a witness takes the stand and says they're going to swear to tell the truth, nothing but the truth, doesn't mean that they're necessarily credible. And sometimes that's what the jurors have to do. They have to evaluate the credibility of witnesses. And here in this case, it was actually very interesting because the plaintiff, whether she was believable, that's a big theme. And also the experts from both sides, because the plaintiff's side had a lot of doctors, a lot of experts, and so did the defendant's side. But, they're both hired, they're both being paid to be experts for their respective side. So then how do you evaluate their credibility? Do they cancel each other out? Or, so that's an interesting theme. So let's continue a little bit and see if they get into how the crash happened.
Maybe who's not. And evaluating the evidence will provide different insights into the ability to answer that question. Okay. There are some legal aspects of this. There's negligence rules, and there's special rules for truck drivers. We're going to look at those. There's special rule. There's rules for us all, and you're going to get those in the form of the jury instructions that the court's going to give you. The jury instructions are going to say, here's what your responsibilities are when you approach a vehicle from behind, when you rear end someone else. Okay. You're going to have different things that you're going to consider, like the statements and different evidence implications. In other words, juries operate great from their gut as well, from who's telling the truth in this matter. So, particularly with truck drivers in California, in order to be a truck driver, you have to have a commercial driver's license, and you have to go through a process to get it. And you have to go through a process of adhering to all of the requirements. A commercial truck driver in California gets far less points on his license than you or I do, than the normal driver does, the non-commercial driver, before they can't do their job anymore, before the state takes away their license. So these rules are ingrained in them, and I have a good faith belief that when I have an opportunity to question Mr. Alzam, the truck driver, that he's going to agree with every single one of these rules and responsibilities. Okay? And California, you're going to see, publishes a manual that sets forth the rules for all to see. Right? These aren't surprise rules, or these aren't guidelines or best practices. These are the rules if you're operating a commercial truck. And we don't have a ton of time, so I'm gonna preview the evidence, but you'll get this, right? So seeing ahead, the importance of looking ahead, how far to look ahead. These are all actually written down so that the commercial truck driver doesn't have to just eyeball it or guess, okay? Stopping distance, controlling your speed. There's an actual formula and a ratio that all truck drivers must apply. Now, you get to use your common sense and your experience. And in your common sense and your experience, you're going to learn through the evidence that, yes, there's rules, and then there's practices, okay? There's rules, and then there's practices. And if the practices violate those rules, that's called negligence.
So this is an important point too, because a lot of lawyers, when they handle a truck crash, they handle it the same way as a car accident. And in a car accident, of course, there are certain rules, like, you have to see what there is to be seen, and everybody knows the rules of the road, everybody who has a driver's license. But for a truck accident, it's different because it's governed by the Federal Motor Carrier Safety Act, and there is actually code of federal regulations. And there are also different manuals, like safety manuals, driver manuals. And then each trucking company, like the big ones, like for example, some of the big trucking companies, they have their own manuals for their drivers. So what you do is you look at those manuals, you look at what they say, and they have really specific rules for like right turns and rules for left turns and rules for changing lanes. For example, some of the manuals say, don't change lanes. Try to avoid changing lanes, because we know statistically changing lanes is going to be more likely to lead to a crash, right? So then you, as a plaintiff's lawyer, if you have those manuals and that's your employer, you could read that to the truck driver, who changed lanes and crashed into your client. So there's a lot of power in using rules in trucking cases, but also it's really critical that you have to understand that these are not simple drivers like, your neighbor is a driver, you're a driver, not a simple driver who got a driver's license. This is a CDL, a commercial driver's license. So these are professional drivers, and they have to have that extra care. And at the same time, some of the trucks are just very large, let's say box trucks or even tractor trailers, and they have blind spots, sometimes called no zones, where people just can't see. And so if there's for example, a pedestrian walking in front of a tractor trailer, he's not seen because the driver's up high in the tractor. Unless there's a crossover mirror, he might not be seen. He can get crushed, right? So all these different regulations, and there's regulations on so many different things, as the driver qualification file, the driving history. There's something called DAC, and that's all the driving history, prior criminal conduct, how they hired the driver, the number of hours they're allowed to drive. So that's a whole separate topic, but this is good that he's making it out to be a professional driver type of case, not a regular car accident.
You have braking distance, stopping distance. I circled this because this is going to become an important fact, and at least to me, it was counterintuitive, right? That empty trucks require greater stopping distances than a full truck. And there's reasons for that have to do with traction and weight and adhering to the ground. But you're going to learn that in this case, he was at the end of a shift. The trailer that he had went from about 30,000 pounds down to 9. He was almost finished. He just had a few pallets left. He was in the danger zone that everybody knows and he was warned about. Managing space ahead. Again, there's a heavy vehicle formula. And I present this to you only to say that we need to, when you're actually evaluating the evidence, not like jury selection, when you're actually getting evidence, it's not just the lawyers talking. There are actual rules that are applicable to this case. And there's actually standards, and they're not Keith Bruno standards, and they're not the defense standards. They are the state of California standards that are based upon how to keep everybody safe. The shared responsibility of safety that everybody has on the road. And especially if you have that endorsement for a commercial driver on your license, that confers with you a great privilege and a great responsibility. Fatigue, that's going to be an issue. You're going to learn that the rules for truck drivers are you cannot drive for 1 second longer than 14 hours in a shift, and the clock starts when you do anything. So the clock starts not when you're driving, the clock starts when you punch in, the clock starts when you show up and have coffee with the boss or whomever, or you're inspecting the guys loading the truck. That's when the clock stops. And you're going to learn that we were at or exceeded that 14-hour period. He's going to testify that it was about 13 and some, but we don't yet know what he was doing when the clock started. But I think everybody agrees that this was at the last point in which it would even be legal for him to be on the road. So we couldn't even go back to the warehouse afterwards, right, without probably violating that rule. He had taken his lunch with him and his breakfast so that he could just eat and go at the same time. He wasn't getting out of this truck. He had worked the graveyard shift all night in the dark. When the accident, when the wreck happened, it was light out, but he had been working all night. The evidence is going to show he drove at an unsafe speed for the truck. He was driving a rental truck. His normal truck he didn't have. He was driving a rental truck. He had just driven it that day, and this was an automatic that takes time to get up to speed. So when he turned off of Long Beach Boulevard, he had to get up to speed, unlike his usual truck. Because the truck was empty, it hopped when he tried to brake, and you're going to see this. You're going to see evidence of this. There's 25 feet of skid marks that is interrupted by a 5-foot non-skid mark.
So that's also very important, right? The physical evidence. That's why I was saying before in a lot of my videos, you want to go to the scene early. You want to hire a truck accident expert or an expert, no matter what kind of case it is, right? If it's a slip and fall case, you want to hire an engineer to talk about what the physical evidence is, take photos, take measurements, preserve it. Here, having the skid marks is really powerful because look, if the truck was really going very slowly and it was a little fender bender, he would not have skid marks, but it's a big tractor trailer and it has 25 feet of skid marks. So it must be going really, really fast. And the lady was stopped waiting to make a left turn in her lane. So she was stopped for a considerable period of time so that the truck driver should have saw her and should have stopped, but didn't and ended up rear-ending her. Let me skip ahead a little bit. He actually plays the deposition of the truck driver in the opening statement. And I think that's very smart too. A lot of lawyers in New York don't do that. Now, the advantage of that basically is that when you take the deposition of the defendant, you just videotape it, right? And then because you videotape the deposition, you can then play it for the jury in your opening, you can play it in closing perhaps, but you also, when you question the truck driver in trial, instead of, impeaching him, let's say he says something different that he says in his deposition. Like in his deposition, he says, I was going 5 miles an hour, but at trial, he says I was going, let's say in his deposition, he says he was going, 30 miles an hour, right? But at trial, he says, no, I was only going 5 miles an hour. So of course, you can then say, do you remember giving a deposition back, 2 years ago? And here's the question, how fast were you going? Answer 5 miles an hour. Does that refresh your recollection? Because now you're saying you were going, completely different, like 30 miles an hour. So which one is it, kind of thing? But if you have the actual clip, the actual video, then it's even more powerful, because if he's in trial saying, I was only going 5 miles an hour, I was super careful, you play the question, how fast were you going? I was going 30 miles an hour. And he actually, the actual deposition from 2 years ago. So that's even more powerful, So let's watch some of this in the opening statement. He plays some of the testimony.
He's got his lawyers, the lawyers that you see here, and he's sitting for something called a deposition. And now the story becomes,
And you always drive as safely as possible, correct? Correct. And you realize that that's a large vehicle that takes up a lot of room. Yes, I do. And it's the type of vehicle that you need to have plenty of distance to be able to stop it, correct? Yes, I do. Especially when it's loaded. Yes.
so he still knows what his responsibilities are.
Yeah. So you're basically, you realize as a commercial truck driver, you have to be a defensive driver, correct? Correct. And what do you do to help be a defensive driver?
I leave plenty of buffer zone in front of me.
So you leave plenty of room in front of you so you're able to stop,
Correct.
given the weight of your vehicle and the flow of traffic.
Correct.
And
This is very powerful too, because if he's, now you're getting it from the horse's mouth kind of thing, right? The defendant who caused the wreck is saying, I have to have this buffer zone. I have to have plenty of distance in front of me so that I could stop. And that's exactly what he didn't do, because he rear-ended the car. So that's very powerful. You get it right from the defendant, and he violated his own standard. Okay, let's jump ahead a little bit and see what other issues we have here. Now he talks a little bit about now a different lawyer comes in and they talk a little bit about what happened to the client. And let me go back just where that begins. This is the end of the liability, and then it will be the beginning of damages.
To decide, and you'll use your common sense. What happened to Layla, is the most important part of the case, and I turn it over to Mr. Rowley.
So first, the glasses, can I borrow your glasses? These glasses, she never needed these. Not like this. They're tinted because her light sensitivity, ever since her brain was concussed, it's almost debilitating. It gets so bad for her, it contributes to bad migraines, but she just can't enjoy light. She can't enjoy light. And this is a woman, this is a young mother who loved being out outside. Loved being outside. There are also prisms in here. You'll hear testimony from a neuro-optometrist who will come in and testify and explain why it is that this young woman has to wear prism glasses that are tinted, and why that's how she lives her life. There's so much more here. This is after she's had neck surgery, shoulder surgery, low back surgery twice, a pain spinal cord stimulator that's implanted in her body, and she's able to walk now better because of that. But it's implanted in her along with the metal and the different things that she lives with. The scars from the surgeries? Yes, this did take on a life of its own. It's their fault. Their fault. The company's fault. And there's nothing these great lawyers can say to change that.
This is an argument, Your Honor. Sustained. Please don't argue.
Yes, Your Honor. So the forces of this collision, you're going to hear about that. It was enough to bend metal, to bend frames, to knock out the back windshield, the back window.
So this is an important point too, right? Like the fact that now, if you have property damage that's serious, you want to use it, because a lot of the arguments the defendants are going to say is like, if it's a little fender bender and there is no bent metal, guess what they're going to say? Well, you could not have been hurt. And they might call what's known as a biomechanical engineer to say, you can't get hurt because it's a little fender bender, right? There's no property damage. But if you have property damage, then you show it and you say, like they're doing now, right? That's the back of her car, the Toyota, the beige car, and it's all completely crushed in. So you say, look, if it's bad enough to crush metal, imagine what it did to her back, right? And you don't even have to imagine that because we have the medical records, we have what it did to her back. She had to have multiple surgeries. So that's very powerful to use that.
It devastated this young woman's life. The evidence will show there's no doubt about it. This was Layla before. An active mom. She grew up, her grandfather, she's Japanese. Her grandfather was here in the United States and ended up in those camps with World War II. Their family lost everything, ended up back in Japan. Her dad was born in Japan, but then the family was able to work and earn enough to come back to the United States for that American dream. She grew up with that history and spending summers in Japan. Layla loves things that grow. Flowers, plants, children. And she came from a household that was broken. Her parents got divorced. And she wanted more than anything to build her own family.
So this is critical too, right? They get to know the client and they talk about themes, right? Things like that. Like she loves things that grow, whether it's a plant or children, right? Because she didn't have a good family. Her parents got divorced. So, but the only way you really get to know that is by going to your client's house, spending time with them, doing calls, and you actually have to do what are called like biography calls, where you get to know your client from childhood until now. And then you ask them for who knows you best, and they give you friends, family, coworkers. Then you go and you interview those people. But that's a really deep dive that most personal injury lawyers don't do. And these guys actually are the ones that do it, and they teach others how to do it. So they're specialists in it. And you could see that it's kind of makes you feel, have empathy for and compassion for Miss Layla, right? Because you know about her a little bit. She loves things that grow. She's Japanese, right? Her parents were in the camps. They had to leave and they're able to come back. So they're overcoming obstacles. And now this is another obstacle, this crash that changed her life. And she's going to try to overcome this eventually too. So you want to tell this story of hope and you want to get to know the client. So too many lawyers just kind of go up there and say, I have a C3, C4, herniation, but for a juror, okay, what's C3, C4? C3PO, like from Star Wars? They don't know what that is, right? It's just medical mumbo jumbo. But this is what allows people to connect with a real personal injury client and then allow for large damages verdicts, like millions and millions of dollars.
And to be a mom. That's what she wanted in life. Some people want different things. She wanted to be a mom. She has children, but she didn't want to be this type of mom. No. She wanted to be the mom that she was, which was involved with Girl Scouts, volunteering, being involved with everything that, if there was something to volunteer and do, she was doing it for her kids, for her community. She loved life. She loved being outside. She was a fisherman. She would hike, loved to travel. And now it's a different life. Her new normal is rough. And the past 8.5 years have been rough. And now her body is aging in a different way, in a way that it should not age, in a way that's unnatural because of the things that have happened to her body through no fault of her own. This was her. This was what she looked like right before. Healthy, active, no prior problems with her body. She could skateboard, could play with her kids, play soccer, do cartwheels, you name it. She was a cool mom that could play with her kids. Every weekend would be an outing somewhere. How are we going to get out? How are we going to move our bodies? Twice a week, she'd do a 10-mile hike. It was in great shape. It changed.
So you see, you show the pre-accident life, all the activities, what you were doing, whether it's work, whether it's fun stuff, hobbies, and then you show how that changed. They also had this animation. Let me jump ahead and show the animation. And I think it's a recreation of the crash and the injuries. And that's very powerful because it's visual, so jurors can connect with that.
She has amnesia. The police officer, it's documented, the police officer noted she didn't even hear the screeching of the tires, the 20 foot mark worth of skids. And the fact that she was hurting is documented in the police report. It's documented that very same day she went into her primary care provider. Glasses were broken. That afternoon, she was so worried about her son, and her brain was concussed. She had to argue, her son actually remembers arguing with the police officer about an ambulance or going to the hospital. She doesn't really remember, and the police officer will testify, and she says, listen, my husband's going to come. She was unable to tell her husband where she was at.
So that kind of is consistent with having a traumatic brain injury, right? The amnesia, not being able to say where you were, and also the animation kind of showing the injury, which is very powerful. So let me jump ahead, see if there's anything else in this opening. Oh, here, they talk about the actual herniation, and this is the actual MRI of her neck with the disc injury, but it's color, right? So the jurors, again, could see the herniation in red, and they see the spinal canal with the outline in yellow. So let's take a quick look at that.
In her arms, in her right arm in particular. And what do they find? They find a herniation. Their own expert is going to say, yeah, the collision did this. She was rear-ended. That caused this neck injury and a need for neck surgery. They'll at least agree to that. November 14th, 2016. And this is not a woman who needed MRIs on her body before she was rear-ended. Now November, so you're talking about 4 months, less than 4 months afterwards, because she has radiating symptoms going on in her low back, and she's got a herniated disc. You're going to find that she had neurological abnormalities. There are changes in her neurological testing and in the strength and reflexes in her right foot because of the damage and the injury to her lower back and her spine. Shoulder MRI, again done August 9th, within a few weeks of the collision. Their expert will say, yeah, the collision tore her shoulder up and she needed a shoulder surgery. Labral tear assist messed her up. Neck surgery, they went in and removed the disc. That was done in April. She tried conservative treatment. She worked hard. Physical therapy, physiotherapy, seeing chiropractors, doing everything, resting, giving her young body a chance to heal. This is not a woman who wanted to have surgeries. She got them done as a last resort. And with the low back surgery, she tried to wait a long time because she was told a third of the time you get better, a third of the time it doesn't do much, and a third of the time it can end up worse. And that's kind of the rule with low back surgery. That's why she needed two. That's why she has a stimulator, spinal cord stimulator in her body for the rest of her life. They went in, they removed bone. This was done March of 2018. She tried injections, tried everything. And you know, you might have defense experts come in here and say, well, we think that the medical treatments that she should have got better. You know what the evidence will show you? The person who wanted Layla Miyamoto to get better more than anybody, it isn't the defense experts, it's not the company, it's Layla Miyamoto. She wanted to get better more than anybody. She wanted to avoid surgery more than anybody. Her and her children, and the man she was married to.
So that's critical too, because if you're the one who wants to get better, then that defeats the defense argument, which is you're not really heard, you're doing this for financial gain, right? You're trying to win the lawsuit lottery. But if you're the one who's really trying to get better and you have evidence of that, you're trying to go to the doctors, you're trying to do physical therapy, you're trying to do injections, you're trying to do, pain management, everything, and then finally there's nothing else you can do except to have a back surgery, multiple back surgeries, but you're doing everything the doctors tell you, everything the medical world is telling you, right? You're trying to get better, and that's what you want. You don't want anything else. So that's very powerful to defeat the defendant's argument.
But she didn't get better. She kept hurting. And no matter how hard she would grit that pain, it continued. It gnawed at her. It beat her down. And you're going to see, it has destroyed many aspects of her life. And she hangs on because she's got children. She has metal and hardware in her body now. This is looking from anteriorly, where they actually take the disc material out. They put in a spacer there, and then they fused her low spine together. We'll go over this in detail with experts. She didn't want this. But yeah, her injuries, they're right, took on a life of their own, because that's what happens when the human body is injured. There is a domino effect. When big, heavy 18-wheelers rear-end human beings, mothers in minivans, the injuries and the damages can take on a life of their own and change the life of the human being. That's what happened. Nothing more and nothing less. These are the wires that are in her body now. You'll see that sometimes at home she has a walker and she's got a cane, because the mornings are oftentimes the roughest, as are the nights. She has not slept a normal night ever since she was hit. As a 34-year-old mom, she had spent a lot of nights being up, being a mother, but not like this. Not because of pain, not because she can't find a comfortable spot, whether it be her neck, her shoulder, her low back, the headaches. She suffers when all the lights go out and everything gets quiet. Sometimes that's the worst for her, because everybody else is asleep and she's alone. Alone with one thing that is now married to her for the rest of her life, that she cannot get a divorce from, and that is chronic pain. Chronic pain. And she wishes more than anything she could get a divorce from that. But she can't. It's a sentence she will live out for the rest of her life. Her injuries, what you will see, are end-of-life injuries. They will last through her life. This is her after a collision. She's had her glasses broke. See some bruising. scars from the surgeries. But this is not what she looked like before. This is not how her life was before she was hit. That's what it was like. But no matter how hard she'll pray or wish, she will never get that life back. And so we are here, and that's why we need you.
So that's critical too, right? You want to show that these are life-changing forever injuries, right? Like you said, end-of-life injuries. You're going to have them until the end of your life. They're permanent. They're never going to go away. And that shows the severity of them. And that's why it's worth a lot of money, as opposed to having an injury, but it goes away. So you suffered for a little bit, but now you're better. Now you're back to where you were before. And that's worth a lot less.
You heard questions by my colleagues on the defense side. They said, what about the surveillance? Because what you'll see, what the evidence will show, is that she gave deposition testimony, as did her treating healthcare providers, and we gave them the Kaiser medical records and all the medical records. We gave it all to the company. And her testimony, and the people that know her, that they're all here to talk to you and tell you how she's changed. And what the company did is said, well, you're going to see. Don't really believe you. So they've sent out their investigators, and just yesterday, they handed me more surveillance.
Sustain.
The evidence will show that just yesterday they...
Well, sustain. We're not getting into discovery issues.
Okay. Well, the evidence will show that there is new surveillance as of yesterday. The evidence will show that of those clips of surveillance, 2 of them don't even have her in them. And the other clip, well, we'll see it.
The other point is, here we're talking about surveillance, right? Because if he doesn't talk about it, then the defendants are going to say, look, we have surveillance, and this is, we videotaped her, and she says she can't do this, but here's a video of her doing it. But if the plaintiff's lawyer just hits it head on and says, look, they just served me with surveillance, they had some surveillance from before, an additional one yesterday, and she's not even in it, and it shows her, I think he's going to say it shows her walking with a limp. So he kind of addresses it head on before he takes the wind out of their sails. That if they start to say surveillance, well, the jury's already heard it from the plaintiff's counsel, so it becomes much weaker. And the other thing I wanted to point out is how the lawyer handles objections, right? Because the other side is saying, oh, objection, you can't talk about this. And the judge is even, siding with the insurance company and the defense lawyers. He's saying sustained, meaning the objection has merit. But the lawyer, it's like a fly, right? He's just like batting it off and just continuing. He's not, some lawyers will get flustered. Oh my God, objection, sustained. And then, that's what you don't want to do. You don't want to let it mess you up. You just want to be in your zone, delivering your speech, and just whatever. Objection, sustained. Okay, I'll move on. I'll go to a different topic. But you see, it doesn't faze him at all, which is very, very good.
I followed her around years ago in 2019. We were almost 6 years ago. And the company had to turn all that over to us. Say, well, if you're going to go around and, follow Layla and her family, then you got to turn that stuff over to us. So we had them turn it over to us. And this is what we found. You can see, watch how her leg moves. Doesn't walk, she never walked that way before. Walks differently now, and she'll testify about that. And sometimes she uses a cane, and sometimes her doctors tell her, if you can live without doing that, then don't do it.
So you see, he hits surveillance head on. Let me move ahead to see if there's anything else in this opening. And then I want to maybe show part of the defense opening so you see their argument as well. This is important. He previews some of the doctors that are going to testify. So he actually has slides with the doctor's information, and he previews a little bit about their testimony.
Life and the camping and the outdoor stuff she used to do, and the 10-mile hike she'd do twice a week. You hear from Dr. Zach. Life and the camping and the outdoor stuff she used to do, and the 10-mile hike she'd do twice a week.
Right here, what they do is they do a
Optometry eval because she's seeing double and she's dizzy and it's blood damages, 8.5 years. That's pain, suffering, loss of enjoyment of life, changes to her quality of life, inconvenience, humiliation, emotional distress. all of that. The judge will give you the items of non-economic harm. There's been 8.5 years of it. There's going to be 41 years moving forward. The damages period in this case is approximately 49 years. The crash happens, doctor's visits. This has been Layla's life. Trying so hard to get better. Trying so hard, wishing that one of these medical treatments, that something is going to make her better, take away her pain, and give her her life back. But no matter how hard she tried, no matter how hard these doctors tried, so many of them, they just couldn't get her back to where she was again. And that's the life she lives. She tried chiropractic treatment, physical therapy, acupuncture. This is a woman who say, here's something that might make you better.
So this is key too, having all of the medical visits to show, look, this is really serious. 168 doctor's visits over 8.5 years while we're waiting to get to trial. 89 PT, chiro, acupuncture visits. So he's going through the timeline of everything.
Do it. Do anything to get better. Anything. And she would trade anything just to get her life back. All the imaging. She's gone through cognitive therapy to get her brain working again. She's tried that even 2023. She's working. There's actual board-certified neuropsychologists and therapists who work with people who've had post-concussion syndrome whose brains just can't get back on track. She's tried. She hasn't given up. She's had injections to take away the pain. Surgeries, April 2017, March 2018, October 2020. You'll hear from all of these surgeons. And maybe throughout the trial we can agree on some things and we don't have to call all these witnesses to prove to you what happened to her. And the judge will give you an instruction that says the test.
And here they talk about some of the doctors that are going to testify either for the plaintiff or for the defendant.
Neurologist from UCLA. We'll have someone come in, talk about how her body moved from the forces of the collision so we can meet our burden of proof to you, since those things are also being disputed. The head of pain management and rehabilitation at UCLA, Dr. David Fish. Brian King, another neuroradiologist, neuropsychologist. We'll hear from a couple of those. And the evidence in this case will show that the life, liberty, and pursuit of happiness, those are the non-economic assets she had. The non-economic damages are 48.5 years. Evidence will show chronic pain, disability, a severely damaged life. And we believe that that will prove to be a reasonable verdict. But it'll be up to you, and you can say it's plus, and you can say it's more. We sure appreciate you being here, but that'll prove to be justice in this case. Thank you.
So another interesting thing that he did in this case, and it's different from I've seen this lawyer handle other cases as well as a lot of other lawyers, is that a lot of lawyers will talk about the past, right? From the date of incident until the date of trial and say that's 8.5 or 9 years and allow for an amount for that, right? 9 million, let's say, $1 million a year for 9 years. And then the future is like another 40 years. So allow for, an amount for the future. But what he's doing is he's making it even simpler. He's just saying, look, the damages period is 49 or 48.5 years, right? Because you have 40 future, 8.5 past. So instead of, making it one number for the past, one number for the future, he's saying, look, the damages period is 48.5 years. And I'm asking for a range between 48.5 million, which is like $1 million a year, to 72 million, which is a little bit more than $1 million a year, right? And that's like the range he's asking for. So let's look at some of the other opening statements. I want to see if I could show you the defense opening.
Thank you, Your Honor.
Since July 18th of 2016,
there is one fact in this case that has not changed. That one fact is that this case comes as the result of a very simple, low-speed, surface street auto collision. That's it. Nothing more, nothing less. You heard Mr. Rowley discuss what the evidence will show regarding Ms. Miyamoto's alleged injuries and medical treatment. The evidence will also show that every single thing that Mr. Rowley told you, we've been aware of the entire time. There is nothing new. So I think he's saying that in order to say, look, we knew about this for 8.5 years, so there's nothing new, right? So if it's really true that she got hurt from this crash, well, how come, we didn't settle, or how come we didn't take care of it, right? We knew about it. It's nothing new. Why are we even here? And this is just a little minor fender bender, right? Little surface street. So that's kind of like a typical defense playbook that he's doing. When Mr. Rowley mentioned to you all the numbers that he suggested, upwards north of $70 million, just as part of what Ms. Miyamoto is seeking in this lawsuit, I believe you all understand now why we're here.
Actually, Your Honor.
As it were.
Well, objection, and I had asked to promote it.
What's the objection?
The objection is that, and basically what it's getting into is what happened before trial. This is
Overruled, I don't see
my
it.
aspect of it.
I don't see it.
Thank you, Your Honor.
I'll respond.
The evidence will show your tasks as jurors in this case will to let common sense remain common. So what he's also saying is that's why we're here, right? Because they're asking for $70 million. And in reality, I'll tell you what happened. I don't know what the offer was, but the offer was not really very high. The offer was probably, I don't know, maybe it was $1 million, maybe it was $2 million, something like that. It wasn't very high. And then on the jury came back Monday, right? That's February the 10th. And they gave a verdict, and the verdict was 21 million, but with interest, it comes out to, I think, 30 something million, maybe 32 million with interest, because they get interest back all this time. So yeah, that was the verdict. And I know over the weekend, the defendant, right around, I think, before the Super Bowl, the defendant offered 9 million, but the plaintiffs trusted their case, they trusted the jury, and they rejected the 9 million, which was smart, because then they got 21 plus the interest, they got 35. So that's the verdict. But what he's saying here is that, that's why we're here, because you're asking for 70. And really, it's a kind of a, goes into the whole tort reform argument, right? That people are asking for too much. It's the whole lawsuit lottery. But they really, as you'll see later, once we do a few witnesses and look at the evidence and we look at the closings in this case, you'll see that it really is, it depends on your perspective, right? Some people might say that it was too much, and some people might say that, no, it's worth that, or it's worth even more. And I think the way the verdict broke down, at least in terms of pain and suffering, it was 4 million past and 10 million future, so 14 million. And then the rest of it was for other things like economic damages, like the medical costs and things like that. You will be the triers of fact and determine if you find Mr. Almazan was at fault for this crash, which is in dispute. Out of these years and years and years of medical treatment, what is actually related to this low-speed surface street automobile crash? So you see, like when he's saying it's a low-speed surface street crash, and he's saying what's really related. So that's an argument about causation, saying like, okay, yes, we had a little fender bender, we hit her by accident, we're not even at fault. I guess they're gonna make some kind of argument that she stopped short in front of them. I don't know what they're gonna say, but and then they're basically saying, well, it didn't cause it. We were not a substantial factor in bringing about these injuries. She probably had it before, or it's from living her life. And that's a typical defense that you see in nearly every single case.
Talk to you a bit about what the evidence will show regarding Mr. Almazan. He is now 50 years old. He is a commercial truck driver. That has been his life's work since he was 18 years old. He has a Class A license, which allows him to operate these vehicles. He went to a truck driving school. He's been driving commercial trucks for 32 years. The evidence will show, ladies and gentlemen, that Mr. Almazan knows what he's doing behind the wheel of these trucks. And what's important as it relates to Mr. Almazan, ladies and gentlemen, is that he does not have to be here. He worked for System Services of America for about 6 or 8 months. He stopped a couple months after this crash. He moved on to do something different, continued driving. But he's here to stand up for himself.
Actually, Your Honor, I'm going to object. That's improper. That's argument. It was dismissed.
Just state the grounds, argumentative, sustained, go.
He worked for System Services of America for about 6 months, and what did his job duties entail?
So the reason that's an objectionable argument is because, as a lawyer, you're allowed to say what the evidence will be, but you're not allowed to make an argument in opening. An argument is saved for closing. The closing argument, right? Opening statement. It's just a statement of what the evidence will be. But if you're making an argument like, oh, he's a commercial truck driver, he's been driving for 32 years, he knows what he's doing, he couldn't have caused this, that's more of an argument, right? Because you have to make an inference that because he's 32 years, whatever, impeccable credentials, he couldn't have rear-ended her, which I don't really get that argument because he did rear-end her. They have the skid marks, they have the photos of the vehicles, they have his testimony. So I don't really understand why they would even make that argument, but I guess they did it. And let me jump ahead to see, I think then he argues that it's really a difference of opinion. Let's see what he means by that.
Of opinion. A difference of how this incident took place, the set of circumstances around how this automobile accident took place, and the years of medical treatment that took place after this simple, uncomplicated, low-speed automobile accident. On July 18th, 2016, when this crash took place, it was at the end of Mr. Almazan's work shift. He had one more drop to go. He was coming from a Church's Chicken in Long Beach, headed to an Arby's in Long Beach. About 10 or 15 minutes was the distance between these two locations. Mr. Almazan has maintained from day one until today the same set of circumstances that were presented to him before this crash took place. Whether questions were asked, whether responses were given, he will tell you the same thing that he's been telling for the past 8.5 years as it relates to this crash. Before I discuss Mr. Almazon's version of this crash, I want to talk to you a bit about what the evidence will show as it relates to Miss Miyamoto's version of the crash. You heard Mr. Bruno make representations about what he thinks the evidence will show as far as Miss Miyamoto's version of this incident. Throughout this lawsuit, we've been told something different. We use this term deposition. Mr. Bruno mentioned it. And for folks that are unfamiliar with the process, a deposition is sworn testimony under oath. The same oath that you would give, and you'll hear folks give when they're sitting on this witness stand at trial, to tell the whole truth and nothing but the truth. And in this case, we had the opportunity to take Miss Miyamoto's deposition on multiple occasions. Opportunities to tell her side of the story, explain her side of the story, and let folks know what her claims and allegations were in this lawsuit. And she did that. And if she followed that oath, she did so truthfully and honestly. And during her deposition, on October 12, 2018, she testified explicitly. She had no memory of the incident. She was unable to tell us what happened that day. She was asked, "Do you remember turning left or about to be turning left?" And the answer to that question was no. I have no memory of the accident. And this is not just Miss Miyamoto testifying to having no memory of the accident. In deposition, you'll also hear from some of her lawsuit doctors, some experts that she was sent to in relation to her claim. And some of those doctors will include a Dr. Zackler. And Dr. Zackler gave deposition testimony in this case. Dr. Zackler will tell you that part of the work that he does when he meets with personal injury plaintiffs is he conducts an interview with them. And he asks them, "What brings you here today? Tell me about the accident. Tell me about your set of circumstances." And he in fact did that with Miss Miyamoto in February of 2019.
So I guess what they're arguing here is that the plaintiff in her deposition had no memory of the accident, and then she told one of her doctors, the treating neurologist, Dr. Zackler, she had no memory of the accident. So how could her version be true, right? But the response to this is that, yes, because she had a traumatic brain injury, so that leads to amnesia. So that's just in line with having a traumatic brain injury, you would lose memory. That shows the severity of the injury. So this is like a little preview of the opening statements. So yeah, let us know what questions you have. Like I said, the verdict was 21 million, and with interest, it was, I think, about 31 or 32 million. What I'll do is I'll do another video where we watch some of the testimony, whether it's from the truck driver, whether it's from some of the plaintiff's doctors, the defense doctors, and then we could analyze a little bit of that, and then we could also analyze the closing arguments. It's a lot to do in one video. To do it justice, so maybe we'll do a few more videos. But this is a really interesting case, and I think it's a good example of trying like relatively simple case, a car crash with injuries like herniations, back surgeries, spinal cord stimulators, pain management, right? Very typical cases. And it also has that traumatic brain injury aspect to it. And it's not like a massive traumatic brain injury with like a subdural hemorrhage or a subdural hematoma, but rather it's the mild traumatic brain injury. And it's an example of, very good example of how to try a traumatic brain injury case, a mild traumatic brain injury case. So I hope this has been helpful. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Bye-bye.